about the executive having unlimited authority?
Well, I'll take the Alien Enemies Act in particular. This is a statute that's been around for 200 years. It's been enforced in various times. And historically, it's been a very deferential statute. The courts haven't scrutinized when it should be enforced, and they haven't told plaintiffs to turn around. So I think we're seeing not only aggressive use of the universal injunction, but also intrusions upon the executive authority.
So I get that. And let me just be clear. I disagree with you. And I disagree with the executive invoking what I regard as a very discredited law and using it to deny due process. So I'm on the side of pushing back against executive authority. So I don't see that as a big problem. Professor Shaw, one of the things people here are talking about is the class action. Mm-hmm. And here's my question with it, and I want you to address this. I had a small town law firm, and I'd have people who walk in, and every once in a while they had a hopeless case that we'd take, and we'd get them relief. And if I had to do that in a 4-person law firm and certify a class action, I couldn't have taken that case. So this so-called remedy of using the class action means that those Vermonters or those folks in Washington State or wherever who go into a lawyer's office to seek relief and that lawyer's willing to take the case, what are the burdens on that law firm if they have to certify it as a class?
Yeah, I mean, it seems to me that, let's take maybe the birthright citizenship example, arguments that challenges can be maintained against this executive order, but they have to be done doing the class action, using the class action device. I'm not sure if those are being made in good faith. Rule 23 of the Federal Rules of Civil Procedure has relatively demanding requirements. The Supreme Court has ratcheted up those requirements in a series of cases in the 2010s. The plaintiffs have to be similarly situated in terms of their injury and the kinds of relief that they are seeking. And the Solicitor General in the Supreme Court a couple of weeks ago didn't disclaim the likelihood that they would be back before the Supreme Court saying, well, you shouldn't even be able to certify a class with respect to this executive order. So it feels to me like a little bit of a heads we win, tails you lose. You can try a class action and we will marshal different kinds of arguments against you doing that. But it is not as though it is very easy to satisfy the requirements of Rule 23. And I think that shifting from these injunctions to a pure Rule 23 based regime would disadvantage those unable to secure representation, who don't satisfy the requirements of class membership, and would mean no relief from government unlawful conduct.
Yeah, and that's one of the things that's so important, hopefully to all of us, is access to the courts for an everyday person in Missouri or Texas or whatever. So you get some lawyers who are just willing to do it because it's a neighbor, it's a friend, it's a cause they believe in. I want them to be able to act and bring that case to court and not have to go through the incredible expense. On the question of universal injunctions, I mean, are there some suggestions you have or forum shopping that you have that would expedite or address what you perceive to be some legitimate problems that aren't siding with the partisan divide on this question?
Yeah. Thank you for that question, Senator. I do think that single judge divisions, which allow plaintiffs to, with absolute certainty, ensure that they will receive a particular judge when they file in a particular division of a district, are an enormous problem, right? That forum shopping is not exclusive to these single judge divisions, but it is the most serious kind of forum shopping. And I should say, as of, I think right now, none of the orders against the Trump administration have issued from judges who sit in single judge divisions, unlike some of the orders issued against the Biden administration. But I do think that the Judicial Conference has already endorsed a proposal that would essentially eliminate these single judge divisions. I think that's something that we should all be able to get behind.
Thanks. Well, I'd be willing to work with my colleagues on some of these practical questions and practical answers where we strip out whether we agree or disagree with the particular decision that's been made by the court. Thank you. Thank you all.
Professor Shaw, you said Congress had set high standards in Rule 23 for certifying class actions. Why would we have set high standards for class actions?
So I don't think I said that, sir. Just that the Rule 23 standards are relatively demanding, that the court has ratcheted up the difficulty of satisfying them.
So, but why would we set demanding standards for class actions?
I'm not sure. The Rules Committee produces the rules, so I'm not quite sure.
But Congress adopts them.
Yes. So I mean, you tell me, sir.
Well, there's a reason we have high standards for class actions, because it should be difficult to certify a nationwide class. And what we are seeing is single judges ignoring the federal rules of civil procedure, ignoring the rules Congress has set out for class certification, and saying, I'm just going to issue an injunction to the whole damn country, and it doesn't matter if it meets even the bare thresholds of the federal rules. Senator Kennedy.
Would any of you advise a client to defy a federal court order?
No.
None of you would? How about you, Professor?
I mean, under most circumstances, we follow, the government and private parties follow court orders. I suppose it's not, I would not rule out ever the possibility that in a sufficiently egregious order, there should be some consideration of whether there's a way.
So in some cases,
I think it's a qualified answer,
in
yes.
some cases you would.
In an extremely narrow band of cases, I think it would be considered, yes.
Okay. Do any of you think that nationwide or universal injunctions are not being abused?
I'm not sure what if I may, Senator, I'm not sure what the time horizon of the question is. I don't think that there could be good faith disagreements about the correctness of some of them, but I have not seen in the last 4 months
Professor, you're
abuse.
smart,
No.
I've read your stuff, and I've read your writings, and I don't want to get bogged down with this, but I have little respect for your opinion because I've read your stuff. When someone is in the White House that you agree with, and someone gets a universal injunction against him, you don't like universal injunctions. You called them judges acting like they're politicians in robes and judges looking like crass political actors. But now that President Trump's in the White House, who you dislike, you think that universal injunctions taste like pumpkin pie. So I have to discount what you say because I think you act on your political beliefs. And I worry that that's what you're teaching your kids. So I'll leave you out of that. Do you think nationwide injunctions are being abused?
Certainly, Senator. I think that is.
They're being abused by both sides, aren't they?
Yes, Senator.
Both Republicans and Democrats are forum shopping, aren't they?
Certainly.
Professor, do you disagree with that?
I think both sides are abusing them. I agree.
Okay. Both sides.
Yeah.
There are no clean hands here. Now, your suggestion is that when a federal judge issues a nationwide injunction, there should be an automatic stay and an expedited right of appeal. Is that right?
Yes, sir.
Do you disagree with that?
I haven't given enough thought to have a position on it, Senator.
I suspect, Professor, your answer will be it depends on who's president.
No, Senator.
Let me ask you about this. What if we had a rule? I was reading an article the other day. I'm not suggesting it. I just want your opinions. That said, if a president, any president, issues an executive order, let's say, that clearly violates settled Supreme Court precedent, that a federal judge can't issue a nationwide injunction. For example, if a federal a president issued an order that said no one in America has right to counsel any longer, including but not limited to, in a felony case, having the government pay for your lawyer if you can't afford it. That clearly violates settled Gideon v. Wainwright. In that case, a judge has no authority or does have authority to issue a nationwide injunction. But in a case where the law is unclear, a judge should refrain from that. Now, obviously, we'd have to trust our judges, but we're supposed to be able to trust them anyway. What do you think about that?
I don't agree with that, Senator, because I think universal injunctions transgress the limitations under Article 3, even if the underlying merits are clear.
I happen to agree with you. I don't think there's any basis under Article 3, under Supreme Court precedent, under the English common law for nationwide injunctions. I think politicians have helped judges, and many judges are politicians, to just make it up. And many of them are like Professor Shaw here. If they like the president, they're against nationwide injunctions. If they don't like the president, they're for him. Professor, let me ask you this while I have you. On April 22nd, 2024, you said there are some members of the Supreme Court that are evil. Which justices were you talking about?
I'll take it your word, Senator. I don't recall using that word, but.
All right, here's what you said. You were talking about the majority opinion in Muldrow v. City of St. Louis. You said, quote, Justice Kagan, will she be able to control the opinion's future distortion by her evil colleagues? Probably not, end quote. Who were you talking about?
Sir, I'm very skeptical. If there's a transcription, it was probably a transcription error. I do not think I said.
No, you said it. Why don't you own up to it? Which you call some of the members of the Supreme Court evil. Now, which ones do you think are evil?
I would have to refresh my recollection. I've been very critical of some members of the Supreme Court.
You made that statement, aren't you?
I'm
You're an officer
Senator, it doesn't
of the court.
sound like something that
you know
I
what
would
I'm
say.
embarrassed at? That you're teaching our kids.
I don't refer to Supreme Court justices as evil
in the
classroom,
on
sir.
Your podcast, April 22nd, 2024.
Okay, well,
big as Dallas. And you're an officer of the court, and you're here advising us to be respectful to federal judges, and you say they're evil members of the United States Supreme Court? Gag me with a spoon. You're part of what's the problem in all of this.
Thank you, Senator Kennedy. Senator Durbin.
So I'm going to give the panel members an opportunity to respond to a question posed by Justice Sotomayor during the oral arguments on the birthright citizenship bill. And she said, I'm paraphrasing, imagine a new president takes office and decides, because of the epidemic of gun violence in our country, to issue an executive order announcing that he will deploy the military to seize the guns of every gun owner across the country. That executive order would be swiftly challenged in a federal district court, or more likely in several district courts. Should a district court be allowed to issue a nationwide injunction to at least temporarily prevent the enforcement of that executive order? I'd like each of you to respond. Professor Blackman.
I actually addressed that point in a blog post. We actually have history of someone in this country disarming everyone. His name was General Gage, and that was not fought with Rule 23.
So your answer?
I don't. If the president came to take everyone's gun in this country, I don't think the remedy would be in the courts.
Professor Shaw?
Yes, I think that whatever the constitutional right is, whether it's a Second Amendment, a First Amendment, a due process right, if a president tries to do something that is in clear violation of settled law, whether we like the law or not, that an injunction is an appropriate remedy.
Professor Alessia?
No, Senator. I've written in support of the Second Amendment in many fora, but I don't think that a judge could issue a universal injunction under those circumstances. Of course, the challengers could seek certification under Rule 23 and then try to pursue class-wide relief.
So do you think it's reasonable to expect every single person affected by an executive order like the one I described to seek relief through Rule 23, or to file their own lawsuit to seek relief?
I don't think that would be necessary, Senator. If you had one person who sought class certification successfully, that would be sufficient. But even if you had failures to class certification, once you get to the Supreme Court and the Supreme Court issues a binding decision, that precedent would bind all the lower courts. So it's not a question of whether you get to a uniform rule, it's just a question of when you get to a uniform rule and by what route. But those limitations on the route matter under Article 3.
There's been a lot said during the course of this hearing about the possibility or likelihood that judges are being selected for this process to review the decisions of the Trump administration on a political basis. Professor Shaw, I noted, I'm not sure you read this into the record, but you said according to a recent analysis by Professor Bonica, the Trump administration has lost 80.4% of the time before district judges appointed by Democratic presidents, 80.4 Democrats, 72.2 before district judges appointed by Republican presidents. Who is Professor Bonica?
He's a political scientist at Stanford, and yeah, so that's in my written statement. And I think it does suggest that it cannot be reasonably just attributed to policy antipathy. This is about a pretty broad consensus about the lawlessness of many of the administration's actions, and I think both Democratic and Republican appointees have seen that.
That's my impression as well. This is not a stacked deck, a statistical impossibility. It is a fact. This president has issued more orders with more controversy than any president in recent memory. I have only been to Amarillo once when I was a younger person. I'm sure it's a lovely city, but it turns out that the Amarillo division of the Northern District of Texas has gotten quite a bit of publicity. It turns out that there are people have been filing lawsuits there because there's only one judge who sits in that division, Judge Matthew Kaczmarek, who I remember appeared before the committee. Litigants knew Judge Kaczmarek would be assigned to their cases and viewed him as favorable to their arguments. So the argument that's being made that venues shopping, forum shopping, is on one side of the table. It is clearly on both sides of the table, and Judge Kaczmarek is pretty well known for the way he rules. Professor Shaw, if you have any observation on that?
Yeah, I mean, as I said in response to Senator Welch, I actually think that those single judge divisions, like the one in Amarillo, Texas, where Judge Kaczmarek sits, are a genuine problem. But none of the injunctions against the Trump administration have issued from judges who sit in those single-member districts. So I'm not even sure it's fair to say that that's a problem we are seeing now and we saw previously. We actually aren't seeing it now, but I do think that regardless of who the president is, these single-judge divisions are a problem that Congress would be well served to address.
Thank you very much. Thank you.
Thank you. Senator Hawley.
Thank you very much, Mr. Chairman. Mr. Chairman, it's great to have this hearing. Thanks for calling it. Thanks to all of our witnesses for being here. Professor Shaw, nice to see you again. Let me just start with you, if I could, Professor Shaw. You talked about the fact that there have been lots of rulings against the Trump administration. That's absolutely statistically true. I disagree with almost all of them. In fact, I think all of them. But the issue of this hearing really isn't the rulings, is it? It's the remedies. Would you agree? And those are distinct things. You may think that the ruling is quite correct, but that's actually not what we're talking about here today. We could have a hearing on that. Maybe we should. But we're talking today about the remedy. And the question is a remedy that binds parties who are not before the court, is that an appropriate thing? I mean, aren't you concerned about judges binding non-parties in their remedies? You may love the ruling, but even if you do, don't you think it's a little bit anomalous for courts to be going out there and binding parties who are not before them? I mean, is that something we want to encourage?
Senator, I think that judges have been issuing rulings that impact non-parties since Marbury versus Madison, right?
So you're not concerned about it?
I'm not. I absolutely think that they can be abused, and
well,
they
no,
have been abused.
Wait a minute. You were very concerned about it just a couple of years ago. Yeah. You said in response to a nationwide injunction on the Biden FDA's mifepristone rules, and I quote, "This injunction's a travesty for principles of democracy, notions of judicial impartiality, and the rule of law."
I think I've been consistent today. That was issued by Judge Kaczmarek in a single judge division. They're a problem. Those are a problem.
With him personally? Wait.
No.
Your testimony is if it's issued by Judge Kaczmarek, it's bad?
No, sir.
It's personal?
That is not my testimony.
Is the problem with the injunction? You were criticizing the universal injunction here.
Issued by a judge in a single judge division. I've been very clear today
So
that those are a
issued
problem.
by a Republican judge in a Republican division, then it's bad.
No, Senator.
Otherwise, it's fine.
No, Senator. I think that single judge
What
divisions
is
are
the
a problem.
principal difference? I'm looking for a principle. I understand you hate the president. I understand you love all of these rulings against him. You and I both know that's not a principle. You're a lawyer. What's the principle that divides when issuing a nationwide injunction is okay, when it's not? When the Biden administration was subject to nationwide injunctions, you said that they were travesties for the principle of democracy. You didn't say the referral to Judge Kaczmarek was a travesty. You said his injunction was a travesty for principles of democracy. Yeah. So, in other words, the translation is just you didn't like the outcome. Is that right?
No, Senator. Look, we're talking about, I don't think Article 3 precludes this form of relief. So we are talking about prudential considerations.
Prudential meaning political?
No.
Then
no.
give me, so far I have yet to hear it. You've been questioned by multiple senators. I have yet to hear a principle other than the fact when you like the ruling, you think it's great to apply it nationally, including non-parties. When you don't like the ruling, it is a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law.
Look, Senator, I'll say, I think I am self-aware enough to know that my view of the underlying legal question, I am sure colors my perception of the remedy. I think that we should all acknowledge that. And yet I do think
and why shouldn't we stop nationwide injunctions for everybody?
I think That's
what we're talking about today.
Because I'm not willing to leave without relief non-parties who are
you're
injured.
not willing to leave without the ability to bind President Trump.
No, I
right?
think that...
I mean, when it's Biden, it's okay. No. When it's Biden, it's a travesty. When it's Trump in office, it's no holds barred, whatever it takes, right?
I believe in a powerful...
What was it that President Biden's staff said? We've got to do undemocratic, unconstitutional things to save democracy. Why is this the same
I believe
thing?
in a powerful president. I do believe in presidential power, but power and constraint are not at fundamental odds.
What is the principle?
Power.
What is the principle? The legal principle. You've referenced prudence. You've referenced the judges you don't like. What's the principle of when an injunction binding non-parties, which was never done in this country before the 1960s? And let's see the chart, the Trump chart, which was done really only once Trump came into office for the first time. You don't think this is a little bit anomalous? You don't think that's a little bit strange?
A very plausible explanation, Senator, you have to consider is that he is engaged in much more lawless activity than other presidents, right?
You don't think
you must
this was never
possibility.
Used before the 1960s, and suddenly Democrat judges decide we love the nationwide injunction, and then when Biden comes to office, no, actually.
It's Republican appointees as well, Senator, and the 1960s is where some scholars sort of locate the beginning of this, but others.
One before then?
Mila Sahoni, who's another scholar of universal injunction, suggests 1913 is actually the first, and others in the 20s.
The Republic endured for 150 years before there was a nationwide injunction.
Well, the federal government was doing a lot less until 100 years ago. So there's many things that have changed in the last 100 or the last 50 years.
So long as it is a Democrat president in office, then we should have no nationwide injunctions. If it's a Republican president, then this is absolutely fine, warranted, and called for. How can our system of law survive on those principles, Professor?
I think a system in which there are no meaningful constraints on the president is a very dangerous system
That's
of law.
Not what you thought when Joe Biden. That is not what you thought when Joe Biden was
every president
You
is
said that is
constrained
not what
and
you
must
said.
be. Absolutely.
You said it was a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law. You also said
the Supreme Court senator agreed 9-0 with me on that
You also
case,
said when Joe Biden was president, you said the idea that anyone would foreign shop to get a judge who would issue a nationwide injunction was just judges looking like politicians in robes. Again, it threatened the underlying legal system. People were just trying to get the result they wanted. It was a travesty for the rule of law. But you're fine with all of that if it's getting the result that you want.
Sir, the Supreme Court agreed unanimously with me in that case, right? There was no standing. The case should never have been allowed to proceed. And the combination of parties without standing and the single-judge division.
No. We're talking. No, they did not. They did not issue a ruling on the nationwide injunction. You criticized the injunction nationwide. Listen,
issued in a case where no one had standing.
Here's the thing. We've now gone 6 minutes, and Senator Kennedy had you for 6 or 7. You couldn't identify a single principled basis. We all know the truth here, which is it's not just you. It's most of my colleagues over here on this side of the aisle, who I respect a great deal, and they were raising very principled objections to the nationwide injunction just 6 months ago, maybe 9 now. And you're probably right. My point is that all that's changed in 9 months is the occupant of 1600 Pennsylvania Avenue. And I realize that my colleagues on this side of the aisle very much dislike that individual, and I realize that you think that the rulings that he has lost are fundamentally sound. We might grant all of that. I disagree with all of that, but we can put that to one side. The question we're talking about here is, should judges, single judges, district court judges, be able to bind non-parties who are not in front of them? And you used to say no, now you say yes. Let's be consistent. I would just suggest to you our system of government cannot survive if it's going to be politics all the way down. Thank you, Mr. Chairman.
Can I briefly respond?
Sure.
I mean, you invoked democracy a couple of times there, Senator. Judges are part of our system of democracy. Democracy is not as simple as majority rule. Judges have always served something of a
You would have it be as simple as
function.
majority rule. When you get the majority you like, you're for the nationwide injunction. When you don't, you're not.
Senator Blumenthal.
Thank you, Mr. Chairman. I'm going to give you the opportunity that I often found absolutely precious when I was arguing before a panel of judges and couldn't get my answer out. I'm going to give you some of my time to just say what you were going to say to Senator Hawley.
Thank you, Senator.
I can't interrupt you.
Okay, thank you, Senator.
I'll take some of your time.
I started to say this.
By the way, we're good friends, so it's not personal.
Well, maybe I'll just finish what I started saying at the end, which is in a number of the questions today, there has been this embedded premise that there's something democratically troubling about judges issuing these nationwide injunctions, constraining the democratically elected president. And I guess I would just say in response that, we have a constitutional democracy, so the people are sovereign, and that's, that sovereignty flows from the people, and we do choose our elected representatives, but obviously we choose our representatives in Congress. Congress passes statutes, the president signs them, and many of the rulings we are talking about were predicated on executive branch violations of statutes that Congress passed. So the rulings in many ways are about protecting and reinforcing democracy. And then finally, I'll say that, courts are part of our democracy, right? They have served this rights protecting and democracy facilitating function from basically the beginning, whatever the original design of the Constitution was. And it is not undemocratic or anomalous for courts to sometimes strike down acts of the president or of Congress when they conflict with the fundamental law, which is the Constitution, which in our system, courts have long had the primary role in enforcing.
And in fact, just as a footnote to this conversation, Congress has an obligation to follow the Constitution too, correct?
Absolutely. The president does, Congress does, every official state and federal takes an oath to uphold the Constitution, but where that oath does not appear to be fully honored by one or more other actors in government, sometimes courts do need to step into the breach. I think that is what we have been seeing.
And I can't remember exactly what that chart said, but so far, in the lawsuits that have been brought, the administration or the president has lost, I would say, a vast majority of times. Is that correct?
The vast majority, yes, Senator.
And I want to ask a somewhat open-ended question because I have to confess, as Attorney General of the state of Connecticut, I probably succeeded, I can't name in which cases, obtaining a nationwide injunction. Then Attorney General Schmidt sought more than...
You started it. Is that your admission?
sought more than a dozen nationwide injunctions against the Biden administration. Then Attorney General Moody also sought numerous nationwide injunctions. This is a tactic, and it's a well-founded one, that attorneys general, litigants, and others have used again and again and again. And it shouldn't be a partisan issue. Nationwide injunctions shouldn't be a partisan issue. And when I say they did it, I'm not being accusatory. I confess I did it. And I don't know about then Attorney General Whitehouse. He can speak for himself, but it should not be a partisan issue, should it?
I agree that it shouldn't be, and but of course, yes, it has been. I mean, I think that despite the somewhat heated exchange I was just having with Senator Hawley, I do think that we don't want judges to be sort of driving the train of policymaking, and there are absolutely, there may be points and there may be contexts in which it does feel as though some fundamental change to the way judges consider nationwide injunctions, how much there's some critique that the merits have become the entire analysis, and that some, there should be some prescriptions that are different about the kinds of harms that should be, the way harm should be evaluated or assessed. So I do think there are, again, back to the sort of prudential point, there are absolutely reforms that I think that there could be some.
Just to take, and I apologize
Yeah, no,
for interrupting,
please.
but I am running out of
Yeah,
time.
sorry.
To take Senator Hawley's point about looking for a principle, a jurisprudential lodestar here, maybe we do need some refinement on a bipartisan basis to provide some guidelines to district court judges, some of whom come to work on their first day and are presented with litigation that determines whether or not kids get health care or whatever in parts of the country they've never visited, in towns they don't even know how to pronounce.
Right. So, and whether that comes from a rule change, Supreme Court guidance, something legislative, I am not sure, but I think there could well be bipartisan consensus around clearer standards that guide judges asked to consider requests for nationwide injunctions.
And that would probably increase the credibility of what courts do if they could point to standards that were not just personal preferences or whims or, perhaps subconscious political leanings.
I agree with that, Senator.
Thank you. Thanks, Mr. Chair.
Thank you. Senator Blackburn.
Thank you, Mr. Chairman. Professor, I do want to come to you, and I want to return to the conversation about calling the Supreme Court justices evil. You host a podcast, correct?
Yes, Senator.
And that is called Strict Scrutiny, correct?
Yes, Senator.
Okay. You made those comments on your podcast. And Mr. Chairman, I would like to submit the recording of that podcast for the record.
Without objection.
Thank you, Mr. Chairman. In that podcast, you referenced, as Senator Kennedy said, to Justice Kagan, an opinion, and you referred to the conservative justices as, and I'm quoting you, her evil colleagues. That is something you said on Strict Scrutiny in your podcast. And you, in that same podcast, you made a reference to Justice Alito. Do you recall that?
I don't recall that. We certainly do reference Justice Alito, so I believe that, but I don't recall specifically
your comment
what.
There was that he was an abject misogynist. So since this is your podcast that you hosted, and this was your opinion on that podcast, would you like to provide explanation about why you think conservative justices are evil and why you would think Justice Alito was a misogynist? Do you care to explain yourself?
I would have to look at the transcript, Senator. I think that the dismissive approach to sex equality arguments in the Dobbs case was deeply concerning. One paragraph in the opinion suggests that there's no sex equality problem with abortion restrictions or prohibitions. I think that's deeply wrong. And in the more colloquial sort of mode of a podcast conversation, that is probably what I intended to convey, that he discounted very serious sex equality concerns.
You were angry and you let your emotions get the best of you, is basically what you're saying.
I don't think I'm saying that, Senator. I was having a conversation, and I am sure I was criticizing Justice Alito. We frequently do on my podcast.
Okay. Would you call that lack of respect?
As in the context of a podcast, we frequently, I will stipulate that we frequently demonstrate a lack of respect for writings of the Supreme Court justices.
That is good to hear that from you, that you have that admission of guilt. So thank you for that. I've got a question for the entire panel. There was discussion about Section 1507 and protesting outside of judges' residences, justices' residents. And I've got a bill, the Protecting Our Supreme Court Justices Act, and it would deter intimidation of Supreme Court justices. And in the exchange Senator Cruz had earlier, he referenced that purposeful intimidation. This would change, it would increase the maximum term of imprisonment for violation of Section 1507 from 1 year to 5 years, and increasing the maximum time, jail time for a protester under 1507 is, I think, an effective way to deter this intimidation of our justices. So I'd like to hear from each of you on this. Professor Blackman, I'm going to come to you first, and then just a very quick, short answer from each of you.
Sure. I think it's a good idea, and I think it should be enforced vigorously as well. We mentioned Judge Kaczmarek before. He's had several death threats against him. They were ultimate plea bargains, so I think there's a serious problem that needs to be addressed with enforcement.
Okay. Professor Shaw?
You know, I think that any law that also touches protected First Amendment conduct would need to be scrutinized carefully, so I would need to take a look. I'm not prepared to take a position here.
Outside of a
No, this is about protest outside of protests or
intimidation.
Okay, so violence, absolutely. I mean, if we're talking about increasing penalties for violence, I would absolutely support that. Yes.
Okay, great. Professor?
I certainly think we need to carefully scrutinize the level of violence and the threats against Supreme Court justices and other judges, as we saw when there was a threat against Justice Kavanaugh's life, right? An attempted threat against him and his family. So it underscores the seriousness of the issue, and I think it's important for Congress to take a look at this.
Thank you. Thank you, Mr. Chairman.
Thank you. Senator Hirono.
Thank you, Mr. Chairman. I kept hearing one of my colleagues accusing you, Professor Shaw, of disliking nationwide injunctions only when it is applied to Democratic presidents. He tried so many times. That is not what you said. That is certainly not what I heard. What I heard you say was in those instances where there's a single judge in a district, that can lead to foreign shopping, judge shopping, which is exactly what happened in Amarillo, Texas. And you said that is something that Congress could address. I think that is a fairer depiction of what you testified to. Is that correct?
Thank you, Senator. Yeah, that was in my written testimony, and I think that I did confirm it today.
So I had introduced a bill to Stop Judge Shopping Act, which would require suits seeking nationwide relief against the enforcement of federal law to be filed in the D.C. District Court. And I explained at the time that I introduced the bill that this court, quote, hears the large majority of cases involving challenges to federal agency action, and its judges are experts at deciding these cases impartially, end quote. That is one of the ways that we can address the issue of foreign or judge shopping, which you did address once again today. Correct?
Yes, Senator.
Yeah, I wish we could take that bill up. So, you know, this attempt of my colleagues to continually attack the Democrats as somehow not wanting judges who decide cases based on objective facts, application of the law, as opposed to having some kind of ideological axe to grind is really more something that they have a problem with, apparently, than anything that we Democrats stand for. Once again, Professor Shaw, there was a suggestion today that case assignments in D.C. is happening in a way that is statistically impossible. And I think this only serves to point out that maybe the person who made this allegation doesn't have enough awareness of statistics or hasn't read the rules in the way cases are assigned in D.C. Do you have any response to the allegation that someone is stacking the decks against the Trump administration in this court, in the D.C. District Court?
Right, Senator. So I've heard both that critique that Judge Boasberg is getting a disproportionate share of the cases, and also the kind of opposite critique that the motions panels in the D.C. Circuit have been more favorable to the Trump administration than random chance would produce. You know, statistically unlikely events do sometimes occur, and I think it very unlikely that there is anything untoward, resulting in the assignments either at the district court or the Court of Appeals level here in DC.
I have to thank you for pointing out how many cases, there have been over 200 cases filed to stop this president from, in my view, abusing his power and engaging in illegal acts. And frankly, and I think Mr. Blackman also suggested this, as did you, Ms. Shaw, that if we don't like this president to be sued, then we in Congress should enact laws that allows him to do whatever the hell he wants. So why don't we let him ignore the appropriations of this Congress? Why don't we let him stop certain grants from being issued? Why don't we let him go after Harvard and any other school that he doesn't like? Why don't we let him go after law firms that take positions that he doesn't like? Why don't we let him do that if we don't want him to get sued? I think that's a rhetorical question, but certainly we could do that. Thank you, Mr. Chairman.
Thank you. Senator Schiff.
Thank you, Mr. Chairman. Michelle, I wanted to ask you about some of the threats we're seeing on the judiciary, but let me preface it by quoting the president, who has called federal judges who rule against him communists. He's called them lunatics. He's called them monsters. He has said that they hate the United States. Of course, he called for the impeachment of Judge Boasberg, said the court system is radicalized and incompetent. His advisor, Stephen Miller, has threatened to suspend the writ of habeas corpus if judges essentially don't fall in line. And as a result, we're seeing judges' lives threatened and their family members' lives threatened. Let me start with the threshold question in terms of a president making these personal attacks on judges for ruling against him, or the policies against the policies of the administration. Have we any experience in our history with this? I mean, there have been presidents, of course, who've been deeply disappointed in judges they've appointed, and of course, many of these judges ruling against Donald Trump or people appointed by Donald Trump. But have we ever seen a president make these kind of sustained and personal attacks on members of the judiciary?
Senator, look, I would say that obviously tension between, sometimes very heated tension between elected officials and judges, presidents and judges who rule against them is nothing new. But I agree with you that there is something different about the tenor of the rhetoric that we are hearing today. And I think that some of the specific suggestions, and maybe I'll offer a couple of examples. One, I do think that including family members of judges in the attacks on judges' rulings is something that, to my knowledge, we have not previously seen members of public office engage in. The proposals to impeach, right? So there's been rhetoric, but also actual resolutions introduced in the House to impeach federal judges for the substance of their rulings is also something that I don't think we've seen. We've obviously impeached federal judges before. That's a constitutional remedy for very serious misconduct, bribery, corruption. Obviously, if the judges engage in treason, bribery, and other high crimes and misdemeanors, impeachment is the remedy. But we've never seriously entertained the possibility of impeaching judges for the substance of their rulings. And so I do think that those threats represent sort of a new escalation that is deeply concerning.
Well, I would certainly agree. I tried one of those judicial impeachment cases of a judge named Porteous, and it was for bribery and other like serious offenses. Certainly not for upholding the law or the Constitution or having a different view of the law or Constitution than a president. In terms of the family members, it's not just the president's criticism, but at least while he was serving as a special employee, Elon Musk was pushing out these threats against members of the Judge Boasberg's family, I think tweeting out or retweeting content identifying who the children are or where they work. And that is just amplifying the danger to these family members. Tell us a little bit about this phenomenon now of people sending pizzas to judges and the implicit threat in that.
Well, I mean, I think it's this is also something that I don't think we've seen before, right? There is clearly some kind of coordinated effort to seek to intimidate federal judges and their families by sending pizzas, communicating the message that their residents, their addresses are known. And some of the pizzas bear the name of the murdered son of District Judge Esther Salas from New Jersey. And the message there, I think, is a very clear one of very serious threat, and I think judges are taking that threat, and the marshals are as well, from the reporting that we've seen, very seriously.
And last question, if you could help Professor put this in the broader context for us, because this attack on judges and the judiciary isn't happening in isolation. We've seen the president now turn on Leonard Leo because these ultra-conservative Federalist Society-approved judges are not proving too right-wing enough for the president. But this comes in the context of the administration also going after law firms. It seems very much a part of a concerted effort to attack the rule of law and using the law to defend people's rights. Tell us a little bit about the broader context.
I do think that attacks on judges and attacks on law firms are of a piece. They seem designed to seek to neutralize sources of countervailing authority and opposition to this administration. And if law firms can't take on unpopular causes because they are scared to run afoul of the president, and if judges are scared to rule against the president, then we really have lost any meaningful check on a president. And as I said in my opening remarks, I think if the Constitution is committed to a single principle, it is limits on power, right? No absolute power. And I worry that we are on a path toward few, if any, meaningful limits on the president.
Thank you for your testimony today and for speaking truth to power.
Thank you.
Thank you, Senator Schiff. I will also note that when it comes to rhetoric against judges, that it was Democratic leader Chuck Schumer who stood on the steps of the Supreme Court and threatened the justices by name. And one of many left-wing commentators who's amplified that message is a fellow named Ian Millhiser, who, when the leak of the Dobbs opinion happened, he tweeted out, quote, "The draft Roe opinion appears to be as bad as expected, but I'm glad it leaked because this leak will foster anger and distrust within the irredeemable institution that is the Supreme Court of the United States." And I guess he decided that rhetoric was not overheated enough, because then he tweeted, quote, "Seriously, shout out to whoever the hero was within the Supreme Court who said, F it," although he did not abbreviate that, "let's burn this place down." That is the angry, unhinged language from the left that has been directed at the court when they dislike the decisions. I want to thank each of the witnesses for joining us today. I want to thank Senator Schmidt for co-chairing this joint subcommittee hearing. Written questions for the record can be submitted by senators up till June 10th at 5 p.m., and the witnesses are asked to respond to any written questions for the record by 5 p.m. on June 17th. And with that, this hearing is adjourned.